Hey there! Let's chat about litigation, a term you've probably heard tossed around in legal circles. Don't worry if it sounds intimidating. I'm here to break it down for you in a way that's easy to understand. Litigation is essentially the formal process of taking a dispute to court. It's how one party tries to enforce or defend their legal rights against another party in a lawsuit. Think of it as the legal equivalent of saying, "Let's settle this in court." Now, litigation isn't just one size fits all. There are various types, each dealing with different aspects of law. We've got criminal litigation, bankruptcy litigation, family law litigation, business litigation, trust and estate litigation, and personal injury litigation, just to name a few. It's like a legal buffet. Personally, we specialize in business litigation and estate and trust litigation. Business litigation is what happens when parties in a business relationship or transaction don't see eye to eye, and one decides to sue the other to enforce their rights. On the other hand, trust and estate litigation often involves beneficiaries who feel they've been shortchanged in a will or trust. Let's walk through the litigation process, shall we? First thing you should know, it's not a sprint, it's a marathon. Even a simple case can take a year, and more complex ones can stretch to 2 or 3 years. Patience is definitely a virtue in litigation. We kick things off with the pleading stage. The plaintiff, that's the person bringing the lawsuit, files a complaint, which is basically a document laying out their case against the defendant. In Florida, the defendant has 20 days to respond, either with an answer or a motion to dismiss. Next up is the discovery stage, the longest part of litigation. This is where both parties exchange information and gather facts. We've got written discovery, which includes requests for production, asking for documents, interrogatories, written questions, and requests for admission, asking the other party to admit or deny certain statements. Then there are depositions, where lawyers question witnesses under oath. After discovery, we move to the dispositive motion stage. This is where a party can file a motion, like a motion for summary judgment, that could potentially end part or all of the lawsuit. If the case makes it past this stage, we're heading to trial. You've got two flavors here: bench trials, where the judge decides, and jury trials, where, you guessed it, the jury decides. Both sides present their case, and then we wait for a verdict. But here's the thing, most cases don't make it to trial. In fact, about 98 to 99% of cases settle before then. Settlement discussions can happen at any time during the process. There's also mediation, where a neutral third party helps both sides try to reach an agreement. It's so effective that it's usually court-ordered in most cases. Remember, throughout this whole process, you've got options. You can try to settle, go to mediation, or push forward with litigation. It's all about finding the best path for your specific situation. Now here's something important to keep in mind. Collecti, our company specializing in B2B debt collection services, can be a valuable ally for any business looking to recover unpaid accounts. We offer both amicable and legal procedures to help you get what you're owed. So if you're facing issues with unpaid debts, contact us. Thank you for watching. Please subscribe to see more useful videos.